Good morning, I'm Mike Woodbury. I'm from Chapman, Tripp, and I'm very fortunate to be joined here by Steve Grant of Melville Jessop Weaver, whose firm administers no fewer than about 25, Steve. 32 now, so they're growing like Topsy. Small, large, medium, and DC and DB and hybrid workplace savings schemes, so very much at the coalface. And also licensed independent trustee Sarah Graydon, who has several such roles, but they incline towards the larger accounts-based bigger end of town, and she has a very, very useful perspective consequentially on some of the really good initiatives that we're going to talk about here in terms of good governance. So the idea today was basically for me to talk to these two individuals who are just examples of people working hard at the coalface about issues that are keeping them awake at night, things that make their roles variously either easier or harder, and more generally what's new and what's seen as looming and keeping us on our toes. We'll try and bowl this in about 45 minutes, and towards the end I do want to talk, if possible, about some of the initiatives coming out of the Workplace Savings Committee of FSC, one in particular that I know several of you have already voiced an interest in this morning, the DB Schemes merger initiative. But just in sequence, so you know what's coming, we're going to talk, hopefully 5 minutes at a time, about firstly vulnerable members, which is a nice place to pick up because it really picks up where we left off a year ago at this conference. Moving beyond the rhetoric into seeing what trustees are now doing to better look out for and care for their extra care members. Retirement planning guidance, cyber risk management, responsible investing. An interesting one is the relevance of how retirement scheme trustees should respond to COFI, the CRD, and various other retail schemes focused new and pending obligations and guidance. You know, they're all very interesting. How should we respond? And just a brief chat about the optimal size and composition of trustee boards and support structures for retirement schemes. And lastly, and with apologies to Tilda Swinton, we need to talk about Gavin. Vulnerable members, so I'll kick off with this one. Trustees have now been told at successive industry presentations that, especially with the FSC's vulnerable member framework, which has now been made public and is up on the website, they should be coordinating with their admin manager to develop a vulnerable members policy. We're not going to use slides, we're just going to talk. It's still relatively early days for restricted schemes in terms of working up appropriately customised vulnerable members policies, but there are some great guidance materials and pointers. And we've now assisted with some of these, and in overview terms we've recommended that they cover the trustee's assessment of when a member should be considered a vulnerable or extra care member, which is my preferred framing. Secondly, how the trustee will go about recording important information on identified vulnerabilities on a member's file so that can be taken into account in future interactions with the member. Thirdly, how the trustee will communicate with and otherwise provide good and responsive services to vulnerable members. And lastly, and importantly, how the trustee will go about monitoring its performance against and periodically reviewing the policy, with this being, we suggest, a standing agenda item at trustee board meetings. So Sarah, are you able to talk please to the policies and systems that your mostly larger and accounts-based schemes are putting in place around that, and also just the incidents and types of vulnerabilities that we're seeing emerge in these difficult times?
Sure. As you mentioned, it's sort of early days for this year, and when I'm talking about the schemes I'm involved in, I'm probably talking about the couple of larger ones in this area. What we have been doing is working, given that both of these schemes have entirely outsourced arrangements, so we have a lot of reliance on our administration manager, Mercer, and they, as luck would have it, have a really great framework in place that we are able to build on and leverage in terms of how we approach this issue. But sort of stepping back a bit, what we have done is look at the FSC guidance, look at the FMA guidance, and come up with policies that we think work for our schemes The aim being partly to make sure that we're coordinating information and availability of resources between us, the administration manager, and the employers, which play quite an important part in this space, because often it is resources and support that the employers offer that we might be looking to direct members to, and we don't want to try and replicate that. So making sure that we have good and up-to-date information about that has been one thing that we've been focusing on, and making sure then that also we're sharing information effectively with the administration manager, who are the people dealing with our members sort of first call day-to-day basis. So that those have been some of the practical areas of focus in terms of what we've been looking to set up. As you say, we have made it a standing agenda item that when we are talking to the administration managers at board meetings, we ask them what they're seeing in this space in terms of any trends or incidents that might speak to member vulnerability. And we also, in both of these boards, we have board members who represent members, essentially. They come from the membership, whether it's union, whether they're elected by members, and so they have their fingers on the pulse of what's happening. So we also, as part of a standing agenda item, make sure that we're getting them to talk to us about what's going on in the employer's space that might create vulnerability, and that we at the board and the administration manager should be on the lookout for.
Yeah, it's really good to hear you mention that. I think it's really important. You shouldn't look to duplicate, you should look to leverage employers' support systems, an EAP if there is one, and the union, the union's help structures if they're there as well. How do you manage privacy concerns in that context when what commends itself is actually talking to for example, an HR assistant or...
So far, the way we approach that to date is that, practically speaking, often the vulnerability shows itself up in the hardship processes, and it is often one of the directors, say, from the association or who will be dealing with the hardship applications. So they are therefore able to provide a bit more hands-on kind of care and advice for that member. And generally we focus on directing them back to resources rather than actually picking up the phone to HR at the employer and saying, oh, there's a member who's vulnerable and you should call them. That's been our approach to date. And also we don't try and gather member information from the employer. We just take what turns up to us in the member's interaction with us. So we don't go out and gather more information about them, and we don't pass information back to the employer unless it's helping the member who's indicated that they want to do that.
Yep. Yeah. Steve, it's all very well to talk about employee support systems, isn't it? But those systems are in the rearview mirror for pensioners and retained members experiencing vulnerabilities. They can no longer utilise support from the employer. I've offered clients some thoughts in that regard, but how do you consider that trustees and their administrators should look to support those members?
Yeah, that is a problem because, like you say, we don't have the... welcome, David. We don't have the employer support for a pensioner base. Many of them have left their employer many years ago. The employer has changed its face and there's no connection anymore. So it's really hard. I don't know the answer to that at the moment. There's obvious practical steps that can be taken. Many of them are of older age. Eyesight becomes a problem, right? So the obvious thing is to increase the font size in any communication, simplify the language. But in terms of an example of a vulnerability might be some out of the blue request to cash in your pension, right, for a lump sum. This is why we haven't developed a policy just yet, because we're trying to work through these scenarios. Is how far do you stick your nose into their family business? That where's this vulnerability come from? Is this a genuine request or is this a vulnerability?
Yeah, and you want to be really alive to those indicia of vulnerability, like, can you please repeat yourself? I don't really quite understand what you're saying, and actually training your guys to be alive to those indicia and actually, in need, point that person towards a support person.
Right, which is typically a family member, could be, you know. And then you go into the power of attorney issues of going through the paperwork, which it can be a hassle for a pensioner. I just want you to talk to my daughter or my son. It's complicated. Okay,
so we're getting there, and there's quite bespoke solutions depending on the demographic. Sarah, when we were preparing for this presentation, you said in conversation, and I thought it was a really nice turn of phrase, that a member's leaving service, and where relevant, a choice between staying in the scheme, where that's on offer, and just taking the cash, is the quintessential moment of vulnerability in a way, which segues us very nicely into the topic of retirement planning guidance. As attendees should now be aware, the FSC's Retirement Planning Guide, developed by the Workplace Savings Committee, has now been launched and is aimed at all persons in either the saving for retirement or the spending in retirement phase of retirement planning. And it's a good document. It covers the key considerations such as investment returns, inflation and life expectancy, and the availability and features of the various sorted calculators and the Society of Actuaries decumulation rules of thumb and how to use those tools. It's quite a generic guide, and that's as a matter of practical necessity, because trustees, of course, operate within information-only constraints. They can only talk informationally to their members under the financial advisor legislation. So it's a useful tool, but only as far as it goes. How do you see it working in practice? And what really interests me is, are your schemes looking to do more? For example, by way of facilitated access to an actual advisor to help members with a little bit of editorial comment to decide whether or not, for example, to remain in the scheme post-retirement and how fast to go about drawdowns.
I mean, one of retained members is an interesting one, because you can't obviously leverage the resources that the employer has. So we have been thinking about how best to support retained members who are making up an increasing percentage of our membership base. And I mean, one of the things is around having a communications plan which looks to address sort of bespoke communications to members in particular groups. So maybe the new joins who might be looking at saving for a house, the people who are returning from parental leave, and retained members, people who are looking at leaving, are another sort of group that we might look at having sort of specific information going out to as a point. So information is one thing. Practically speaking, been looking at trying to provide better options for how they can access their money once they have left. And also at the police scheme, we are trialling a limited financial advice service, which I think, so with Mercer, and that's just kicked off, I think July it was, so really early days on that. But I would hope that that would be really useful to retained members, and also, I mean, members in generally, we're hoping there'll be a number of them who take it up, but particularly that feels like it could help plug a little bit of a gap for those members who no longer have access to support through employers.
That's really good. And there's a sense in which where Australia goes, we follow, and they're seeing that 26% of assets in Australian retail super schemes are held by retirees. That's expected to grow to 35% in really short order. Last year, the Australian government put in place a retirement income covenant, which not only empowers but requires trustees of those schemes to actually proactively engage with certainly retirees at the point where they look to superannuate and they're given some optionality, and actually gives them some advisory powers in that regard. One of the really interesting things that empirical research in Australia showed is that one of the reasons that's so important is too many people are not drawing down their money fast enough. They've saved a decent nest egg, and they're actually living out of a baked bean can, and they're not enjoying the drawdowns at the rate available to them actuarially or as a matter of applied common sense. So that's quite interesting. Really cool to hear that actually, because I think the tool is great, but it doesn't go far enough. Actually, you're looking, where practicable, to put in place an advisory service. That's just fantastic. I'll move on to cyber risk management. We'll keep it snappy. Steve, certainly the topic du jour. Key area of, thank you, Joe, for the painkillers. A key area of focus for scheme managers and FMA, with the scale and the cadence of data breaches increasing year on year. We've been reminded by FMA that although restricted schemes work to a full outsource model, in other words, they'll likely have fully outsourced to third parties their registry and their admin function and of course their funds management, attacks on supply chains are very much on the rise. And trustees can't outsource legal responsibility. It won't wash just to say to FMA or the Privacy Commissioner, we outsourced this function to a third-party provider, we did our due diligence, therefore we're not liable. Can you comment, please, on the admin and investment management aspect in particular, the cyber risk that each presents, and how, from your perspective, those risks are best monitored by trustees, the policies and practical measures that should be put in place to protect scheme information from cyber attacks?
You're definitely right that it's a topic du jour, because FMA have also talked to all the audit firms, I suspect, because all of our 31 March audits, that was one of the observations in the report to the management trustee, was that they need to be looking into their cyber security and their service providers, which, as you say, is the admin manager and your investment manager as well. So the problem is, how do you document and evidence that you are keeping on top of the cyber security arrangements at these service providers? If you're lucky enough, you've got a trustee on the board that is an interest in these things and understands what is a good policy and a bad policy. There are other trustee boards that are leaning on the IT service within the employer sponsor and passing on any cyber report documentation to their IT crowd to review that and report back to the trustee board. The third option, I think, is to request from your service providers some kind of certification that everything's okay, and record that you've got them into a trustee meeting and grilled them, and you've got a piece of paper that says everything's all right. Probably the extreme case, more costly, is to engage your own IT crowd to review the security processes that you provide us.
Sarah, just on the penultimate point, getting assurances from the relevant provider about cyber risk protection. There's the challenge, isn't there, of how not only how you get meaningful assurance from providers in this area, but also the fact that it's all very well to get detailed reports. How does the board have the right expertise to critically engage with the arrangements that are in place? And do your schemes have any process suggestions for managing that issue?
I don't think any of us really look forward to wading our way through the kind of massive reports that seem to get on cyber security. I mean, for a start, where it is a regular report that we receive on an annual basis outlining what is in place and also the sort of checks that have been carried out. And so I think any of the board are well enough equipped to critically engage with the information in the report and sort of look for obvious holes from a, I'm going to say, layperson's perspective, because none of us have an IT background on the boards I'm thinking about. But then the question of, well, would we know enough to spot any obvious gaps or inconsistencies is something that we think about, and recently have taken an extra step in one of the schemes of submitting it to someone who does have expertise in the area, leveraging, luckily, resource available at one of the employers to provide us with a bit of comfort around that, which was a useful exercise. But to me, that is something I think you have to think about doing every now and again, maybe not every year, but it certainly, I found that provided me with more reassurance than just looking at it myself and thinking, well, it looks all right.
Well, what
it
about,
isn't really enough, I don't think.
Yeah. There's a soft underbelly too of the distribution of trustee board papers via Extra or Outlook or wherever, and they're held by the individual trustees/directors on their own desktops, etc. How might that risk helpfully be mitigated, and does it merit having a data management policy or similar? Because from my perspective, it's absolutely essential that you retain member records back to the year dot. You might be walloped with a claim, as is frequently the case, or it just makes common sense to have all of the raw material relating to everyone's retirement journey. But what about retention of quite sensitive papers dealing, for example, with morbidity claims on an individual trustee's own laptop? Policies perhaps to cleanse those at intervals?
I think that would be sensible. I'm quite lucky in that all the boards I'm on use Diligent, which provides a sort of secure central repository, so you don't need to worry so much about papers sitting out in people's personal email accounts or saved in places that might not be secure.
Or physical papers as well. We've still got trustee boards that receive pieces of paper.
Yeah.
And we don't know where they sit, but there's an expectation that trustees would look after those papers, but they won't have them for all the years they've been a trustee, right? So they must chuck them in the bin. I don't know.
I always
Put them in the
thought
fire.
best practice is to just hand them over to be shredded at the end of each meeting.
That's a good point.
Fair. Yeah.
So actually this risk, of course there are some big scary reports that are hard to deconstruct, but it's actually prompting a few quite good common sense initiatives, isn't it, around just protecting that protecting members' privacy.
I think if you're sending them out just via email as attachments, then you definitely need to have some rigour around what then happens to them, and because the individual board members shouldn't need to keep them on personal devices as long as they're held centrally somewhere and they can access them.
In need, yeah. We'll move on. Responsible investing. I loved Matt Winneray's comments just last week, encapsulating why critics of sustainability-focused investing have their heads stuck in the sand, asserting, for example, that ESG investing is an exercise in virtue signalling and detracts from funds' core purpose of financial returns. He said, look, those investors who have been criticised for the incorporation of ESG are just doing the only sensible thing, which is to incorporate those considerations into investment decisions. They're relevant, they're fundamental to long-term risk and return for the long-term benefit of the investments. Perhaps Sarah and then Steve, in each case very briefly, what differing approaches are currently being taken by your restricted scheme clients in the context of responsible investing? And what issues do you see looming in keeping trustees on their toes in that context? Because the debate about prudence is now settled, but where are they sitting on the spectrum, between complete diffidence and going into it boots and all?
I would say that the couple of schemes I'm sort of talking about generally here are probably about middle way along the continuum. I mean, we have responsible investing as part of our SIPO, and it gets factored in to investment decisions to some extent. There's a sort of usual approach of exclusions of some types of investment. Our investment managers provide a breakdown of rankings or ESG rankings for the fund managers that we use, and we also ask that ESG factors, and particularly climate risk, are factored into investment decisions. Not that they're the sort of ultimate deciding point as to what gets invested in, but that climate risk is considered in terms of how the investments are made. Whether that's enough or whether that's might change over time, I'm not sure. I think one of the things that we are thinking about is, even though we're not caught by the new reporting regime that's in place, how we could look to apply some of that to the schemes. And one area of focus so far has been on measurement and understanding the carbon intensity of our portfolios, which seems like a good starting point.
Steve?
So less so in a pension fund. It's an issue that's addressed in all their SIPOs. But there's a recognition that you as a trustee board don't have any direct influence on which investments are made, but it's always part of the consideration when selecting a manager. If you've had Andrew Bascan turn up to a trustee meeting and talk about his harbour investments, he's always telling everybody about ESG scores on all the things they're doing and all of those good stuff. So it's always at front of mind at trustee meetings. It comes up into consideration if you're looking to change your manager. But I think if you ask the average pensioner if they cared deeply about where your funds were invested versus to make sure there's enough money to pay my pension, I'm not sure there would be too many that would care deeply enough about that.
Yeah, but a meaningful number of your client schemes have adopted and they've baked in responsible investing policies into their SIPOs.
Oh, they're all in their SIPOs, yeah.
Actually, I've got a bit of a homily on this. I actually see there's a little bit of a risk looming, and it's something to keep in mind, even for smaller pension schemes. Look, I think there are potential legal risks that need careful management with the adoption of a responsible investing policy. Even though the investment case for adopting the policy may be, and frankly is, unassailable, I'm getting at the risk of the policy, whether it's standalone or incorporated into the SIPO, asserting that the trustee board will do things which it doesn't then do in practice. Now, that might not rise to the level of greenwashing per se, of the kind that's gotten Mercer and latterly Vanguard into trouble in Australia, but it could be a breach of the fair trading rules or just a material misrepresentation. An example might be, and this is quite a common set of words, they're almost templated at this point. Look, we can't look under the hood, we can't tell our fund managers what to do, but on a regular basis, the trustee, with the assistance of its investment consultant, will seek to assess its external fund managers on their responsible investment policies, their engagement with ESG entities, and their portfolio metrics like their carbon footprint. In that regard, we will, we'll ask them each year to attest to that. We'll require them to address climate risks and opportunities as a specific component of their investment considerations. Now, that's a good and very careful iteration of we can't tell our managers what to do, but we will monitor them. Standard. And that's all very good. But it's vital that the trustee board, of course, then does those things and can evidence doing so. So it's not just voicing an aspiration, but saying what it will do. So to mitigate the risk of misrepresentation, trustees need to be very careful to ensure their RI policy is truthful, accurate, and avoids assertion or exaggeration. Only promise what you can and will do. So I'm very much an advocate for keeping it simple.
Just on that point, I think you actually should take the same approach to cyber, because there's no way you can say it's all covered. And I think you face the same risk there by saying you're actually doing, you've got to not say you're doing things.
Yeah.
Because it's exactly the same
Yeah.
situation.
It's this actually threading this needle and saying we'll ask them, we will prefer managers who are able to tell us that they're signatories to the UN PRI, that they're members optimally of the RIAA, that they do all these nice things. But iterating, we can't control that. All we can do is monitor, and if issues emerge, ask them to explain. In the event they can't satisfactorily explain, look for another manager, but being very, very explicit that and not giving assertions about what's actually under the hood. I agree.
It's worth mentioning that some of the members are very engaged on this.
Yeah,
and
it's
not
true.
unheard of for people to request an entire list of all the underlying holdings. That
I responded
that
to just such a question.
then go through it
2 days ago.
See, what is being invested in. So, and I mean that's fine. You should welcome that kind of engagement from members, but people do care and are actually willing to dig into it a little bit.
But you have to be very straightforward in reply and not over-egg the response. So in that instance, I told my client, look, we are what we are. You can reply to this person who was a member of XYZ Limited sustainability team, so we should have seen it coming. We adhere to the following high-level responsible investing principles. We can't and won't assert that we're free of fossil fuels. We don't know what we don't know. We can't, there's certain things we can't attest to. You've got a choice of funds, kind regards. It's that simple. Really interesting one. I'll move on to the issue of all this sort of avalanche of CRD reporting and account assurances and COFI and so forth, conduct of financial institutions. This plethora of stuff where, because we're good advocates, you word search the word restricted, and you'll see that restricted schemes are, of course, ostensibly exempted, ostensibly freed from compliance with all these new duties and all these new guidance requirements. But there's an issue, isn't there, of how restricted schemes should respond to the many legal duties being imposed on licensed managers and to other licensed manager-focused FMA guidance. Can you just ignore it in a nutshell? My own personal view on that is fairly straightforward. You need to engage with it, but the answer is you do so selectively but actively. Obviously, the law and guidance on developing climate scenario narratives or keeping CRD records for climate reporting entities, for example, has no immediate real-world relevance for restricted schemes. But there are plenty of other examples where, though a restricted scheme is not caught, so to speak, by a new requirement, how FMA guides compliance and retail scheme managers comply will doubtless deliver valuable real-life learnings for trustees. In other words, you'll receive good IQ from engaging with this stuff. A good case in point is the COFI requirement as a licence condition for robust business continuity planning to guard against cyber threats and other forms of business disruption. Consultation on those requirements remains live, and the core requirement is you must have and maintain a business continuity plan that is appropriate for the nature, for the scale and scope of your market service, and be able to protect confidentiality, integrity and availability of information and or IT systems. Now, to my mind, doing that is just an outworking of any scheme manager's best interest duty. And the draft licence requirements give some excellent guidance on doing just that. Now, many of the requirements are technically disapplied to restricted schemes, but that's just because their trustees don't need a licence. They're most definitely relevant. Likewise, the fair conduct principles and the fair conduct program requirements imposed by the COFI legislation are just useful reminders of how to ensure trustees can demonstrate conformity with core fair conduct principles. So can each of you, again, perhaps Steve and then Sarah in that sequence, comment please on whether, and if so, how, those law reforms, licence conditions and associated FMA guidance aimed at retail schemes are just being brought to your board's attention as relevant from a good practice perspective, and how they're influencing the adoption and tightening up of, say, new or improved trustee policies.
So how they come to the board's attention would be three areas, really. One would be from your licensed independent trustee who has come across these guidance notes through their own research or through other trustee boards they're part of, bigger boards. Similarly, your admin manager who's in contact with a wide range of trustee boards who are more heavy duty, more engaged in this this area compared to a 12 pensioner fund that's got 2 trustees, right? And the third one is from the legal advisor. Every now and then it wouldn't hurt to get them into the trustee meeting to share common sense interpretation of all these guidance notes that come out of the FMA. Because one of the things is the FMA are issuing all these emails every week. All these guidance notes come out and best practice, and it's aimed at the retail space, like you say. There might not be anybody on the trustee board who has the intellect to interpret what's good stuff to bring into our little restricted scheme and what's stuff that we don't really need to care about at the moment. I mean, we've still got trustee boards that are just slowly moving into a general good governance type of arrangement, right? We've got trustee boards that are still quite stuck pre-FMCA world. So we're slowly, and you've got to move slowly with these things.
And yeah, so without gazumping Sarah, there's also some other common sense examples, isn't there? There's the value for money guidance. You know, that's just helpful. And the guidance on keeping good accounting records, the 10 core principles.
I mean, the sort of starting point is to take that guidance and see how it is relevant to the scheme. I mean, my general view is that even though it might not technically apply, you should still be looking to see how relevant it is and what you should do for it. Because I don't think our members would expect us to be holding ourselves to lesser standards just because we've managed to be exempted from the guidance. So generally, my view is that anything that comes out, you take it, assume that there will be some application to the scheme and look to see what a sensible way of thinking about that guidance is for your scheme. I mean, the accounting records one was a good example. The value for money guidance was a really useful exercise to
They're
go
not
through.
disapplied, I should add. Actually, they apply to all registered schemes. I
generally think that there is value in looking at how they apply to the scheme and going through the discipline of that, even though you might not, strictly speaking, need to comply with all of them. And I haven't really engaged with what we might pick out of COFI yet. I sort of like to wait until it's all sort of nicely settled and then look.
I think that's a good point, and that's another one where you'd actually look after the event to what can you plunder from really first-class fair conduct programs.
Very much
all
so.
of which are going to be
There's no need
published.
to invent it from scratch when there'll be a whole industry around compliance and making sure that for those who have to comply with it, you may as well learn from what they're doing.
Cool. I want to leave time for questions. So the size and composition of trustee boards and administrative support structures. Steve, we're at the tail end of a maturity curve in this sector. And as membership of many restricted schemes reduces, you're having some experiences with sponsors and trustees starting to consider the appropriate size and composition of the trustee board. We have talked conversationally about legacy structures where the scheme in question was once a hybrid with thousands of members, is now pensioner only, and still got the legacy board size whereby it's frankly over-governed, to give that example. Can you briefly elaborate on what you're seeing there?
Yes, so we are seeing that. One of the issues is the member rep trustee. On many of the pensioner boards, all of the members of the scheme are old age pensioners who haven't got the time or capacity or interest really to join in the trustee board. And so many of the trustees have a requirement for there to be one of those trustees. So they're having to go and amend the deed in a common sense approach to reduce the number of trustees required and who they should be. The other feature that's starting to show is frequency of actually meeting, where there's a very small pension fund, again our 12 pensioner fund with $2 million, nothing happens. Some of those are meeting just twice a year, still get their quarterly papers, and they meet just not meeting quarterly anymore. There's nothing really going on. But it's the finding the right, because the other trustee board appointments are employer-appointed trustees, and they're just too many of them in some cases as the membership shrinks. So again, that's often written in the trust deed, so you're going to need to do some deed amendments to reduce the need. But there's no magic formula of what the right number of trustees is for the right size of fund or number of members.
Sarah, what are you latterly seeing in terms of governance arrangements for smaller / closed schemes? And are you able also to talk briefly about efforts to add diversity to boards?
With the couple of smaller schemes I'm involved in, I mean, it sort of comes down to a right sizing perspective as the number of members drop and the cost of perhaps maintaining the existing structure starts to look less like value for money for the members, then I'm seeing some consideration being given to other options there. And there is a very small scheme that I'm involved with that I'm always encouraging to try and move to a more sustainable option, but they
Future state.
are quite resolutely refusing to at the moment. In terms of sort of the bigger boards, always looking for diversity of experience in terms of who we need to have around the board table, and often for some of these boards, bearing in mind that you actually have elected members, so the memberships in some ways make up their own mind about who will be on the board, which I think is quite a useful mechanism. I think it's a sort of ongoing task, really, because if I look at the boards that I'm on, there's an element of diversity, possibly reasonable gender diversity, but certainly not much ethnic diversity. And yeah, that's something that we're mindful of, but also have slightly limited mechanisms for how we can address that, given how the directors get appointed.
Last word to you, Stevie Ray. Thank you, Sarah. The post-Gavin Quigan era, we know that we have very much valued and continue to value his encyclopedic knowledge of where all the bodies are buried, but also of the ledge, and his profound sense of pragmatism and what matters and what doesn't. We're really lucky to have such an engaged regulator who is no fool. He can smell bullshit a mile off, but various initiatives, be they amendments, commutation exercises, restructurings, more generally bulk transfers, they're just better for Gavin's involvement. He's not immortal. What do you see looming in terms of risk in that regard? And
I see that as a huge risk.
Yeah.
Personally, I see that he is a significant filter, as you say, of the bullshit from he stops FMA rubbish coming through to the restricted scheme world. I'm sure that FMA see him as a point man for, let's just run it past Gavin to see how it's going to fly down in restricted world. And he also filters a lot of the what looks like trouble or not non-compliance is a strong word, just the issues going on in the restricted world that a box ticker inside the depth of the FMA would get all excited about.
I think that's
But I
right,
think
not
Gavin
getting it
would-
wrong, but just overreacting.
Yeah. And Gavin would come in and he'd have a quiet word and say, you need to tidy this up, or where's your information on this or that. Whereas I think there's a high risk that a replacement of Gavin isn't going to have that industry knowledge, that deep history of how we operate. And I think it could be a bit of trouble.
All right, so some of these various initiatives are somewhat time critical. We're on deadline, so I just want to talk very, very. Thank you both. That was a really good discussion, really free forming, and I found it really interesting. As promised, just a really brief overlay of what the workplace selectively of what the Workplace Savings Committee have been doing of late. We're looking at, most of our client funds have suitably conditional and in practical terms full exemptions from the AML CFT statute. As you know, those exemptions are currently under review. We've had them rolled over for an interim period of another 18 months. We're in conversation with the Ministry of Justice to leave them intact, and indeed as regards aspects of the conditionality, make them a little bit more scheme friendly. So we're looking to we're engaging with Ministry of Justice on rolling, because actually we're invoking two back-to-back exemptions, one in the regs and one in the class exemptions notice, rolling them up together into one evergreen regulatory exemption, which actually doesn't need renewal, it's just there, and looking at some of the conditionality which is proving problematic time and again, particularly for schemes like David's and others that have got maturing memberships. It makes zero common sense to superimpose, for example, a maximum rate limit on a member's contributions. If contributions are paid via payroll, they are by their nature free of money laundering risk. So if a person that's nearing retirement wants to contribute 80% of their salary because they've got a higher earning spouse or just because they can, they should be able to fill their boots. We'll have a conversation also about members being able, subject to appropriate conditionality, to indeed contribute through bank accounts, acknowledging that the conditions for doing that would be that of necessity we would look them up and down and thoroughly CDD those individuals. Recent submissions activity, we're always alive to tax increases by stealth. We swatted one away last year whereby pensioner contributions were to have been automatically taxed at an ESCT rate of 39%. We got that rolled back to the pre-existing proxy rate of 33% retroactively so that all schemes were held harmless. One of the proposals around the current trust law changes is that schemes which don't qualify as widely held super schemes like family trusts will now be taxed at 39%. I guess if the current government gets re-elected, that catches pension schemes with fewer than 20 members. We've written a very, because they're no longer widely held, so we've written a very forthright submission saying they shouldn't, not only should they not be taxed at 39%, they should indeed be able to enjoy the 28% proxy rate. So I think we'll prevail there as well. And probably my magnum opus of late has been the DB Schemes Consolidation Initiative. So this is the initiative that a good many of you are familiar with. The report is now final. It's being FSC branded. It'll be released fairly shortly. This is the idea that there are far too many DB schemes and DB sections within hybrid schemes that are far too small to have any business existing. The employer, typically Omnicorp Worldwide Limited, is quite comfortable with an ongoing underwrite, but is driven up the pole by the need to have a standalone special purpose trustee company, its own legal advisors, actuaries, admin managers, yada yada yada. It's too much. So the idea behind this solution is that we're looking to create enabling legislation and enabling exemptive relief that will allow those pension schemes that are too small to have any business existing to essentially merge into another restricted scheme. So the scheme operates in the restricted schemes environment with one governance board, one admin manager, one set of advisors and service providers, one set of fund managers, pursuant to the bulk transfer facility in the FMCA, and on the basis that each employer signs a participation agreement, much like a master trust participation arrangement, just a contract. Each respective plan within the master trust enjoys accounting segregation, and we don't have whole of scheme accounts. We just have financial statements on a plan by plan basis. We have plan by plan actuarial reports. The push factors are that there are 22 schemes and counting that are pensioner only and that are worth south of $20 million. They incur average non-investment costs, admin costs, of 128 grand as best I can estimate. Even pensioner only schemes are only, so schemes worth less than 20 million, 128 grand, pensioner only schemes that are 120k. This solution is not necessarily confined to the small end of town. We know that it will appeal also to the sponsors of certain larger pensioner-only DB schemes that have just they're not enamoured with having to convene the CEO, CIO, or CFO around a trustee board quarterly and just be ultimately responsible for the governance of a managed investment scheme. There's a lot to the report. I won't attempt to summarise it. It's got good support from FMA. We anticipate good support from IR for the requisite amendment to the relevant provision in the tax statute. It's probably a 2-year initiative, but the light on the hill for me is actually barrelling all of those smaller DB schemes into a master trust / warehouse. They're still there. Pensioners are held harmless, and employers are just shrived of that governance responsibility, and by my estimate, probably a third of their costs. So I hope that's helpful. Thank you again to both the speakers. Thank you for the questions to the extent we've had them. We've got a little bit of time now to engage with any queries. We've got to be somewhere else in a couple of minutes though, so I better knock it on the head and maybe we'll do a walk and talk. Thank you.